Hello everyone, welcome to the video lecture of Intermediate Paper number 5, Business Law and Ethics of CMA Inter. Previously, we had discussed briefly regarding the important topics in each chapters. Currently, we are at Sale of Goods Act. Already a video has been uploaded discussing what are the important topics considering the previous examination. In this video, this is a marathon where important topics of Sale of Goods Act will be discussed. Students must notice Sale of Goods Act in particular is a chapter where there are large amount of examples present. In previous examination, the most repeatedly asked pattern in Sale of Goods Act is a scenario is given and you are asked to give a legal opinion. For that, you are requested to go through examples given in the chapter itself. In the video, we will be covering different concepts for easy understanding only. So let's get started. What are the important topics? As far as Sale of Goods Act is concerned, one of the important topic is contract of sale versus agreement to sell. So contract of sale is an executed contract, meaning it has already happened. Agreement to sell is an executory contract, meaning it is happening in future. The property of good process from buyer to seller. The transfer of good has happened in case of a contract of sale, whereas the transfer of property take place at a future time or subject to certain condition to be fulfilled in case of a agreement to sell. Once you have an understanding of basic concept, you will be able to easily bifurcate or differentiate. Sale take place only for existing or specific good, whereas for sale, agreement to sell future and contingent good. If goods are destroyed, the loss fall on buyer. If goods are destroyed, loss fall on seller. The seller can sue the buyer for price and damages in case of breach of contract. The seller can sue only for damage. This is one of the important differentiation between contract of sale and agreement to sell. Contract of sale, buyer can sue for price and damage, whereas in agreement to sell, buyer can sue for only damage. It gives buyer to enjoy the good against the world at large, including the seller. It gives a right the buyer against the seller to sue for damage. So you can understand the concept easily. What are the essential elements of conditions for a contract of sale? There will be two parties. You can go through that. These are all different kind of example. So another concept in the chapter is condition versus warranty. A condition is a stipulation essential to main purpose of the contract, the breach of which give rise to treat the contract as repudiated. A condition in a contract of sale is the fundamental nature for which buyer can, for breach of which buyer can repudiate the contract. So this is the most important keyword in the definition. Wherever or whenever you are writing about condition, you should include the word repudiate because it is a key factor that differentiate between condition and warranty. What is a warranty? A warranty is a stipulation collateral to the main purpose of contract, the breach of which give rise to a claim for damage, but not to reject the good and treat the contract as repudiated. So, what is the difference between condition and warranty? A condition is a stipulation which is essential to the main purpose of contract. A warranty is a stipulation which is collateral to the main purpose of the contract. So, condition is part of a contract. Warranty happens after the contract is entered. A enter agreement with B to sell a iron box. That is a condition. There can be condition in the contract. Maybe he can say for the sale, I have to get 100 or 1000 rupees for the sale. That is condition. Once the iron box is purchased and later on it get damaged, we has the right to get it replaced. That is warranty. But iron box is his only. He cannot return the iron box. He can get a new iron box. He can get it free of cost repaired. But the contract cannot be repudiated in case of a warranty. That is a key difference. The aggrieved party can repudiate the contract of sale in case there is a breach of contract. So, whereas in case the aggrieved party can claim damage only in case of breach of warranty. So, this is a key difference. So, there is a repudiation clause in condition, whereas there is only claim for damage in warranty. A breach of condition may be treated as breach of warranty. A breach of warranty cannot be treated as a breach of condition. So it is very clear. In condition, warranty is already included, whereas in case of warranty, there is no features of condition. Because there is no repudiation. One concept we missed. Huh. So this is another important topic. You are required to know about this doctrine. That is, imo dat quod non habet, which means no one can give what he himself does not have. So today here I am saying I will give 1000 crore rupees to poor people. If I am saying that, what is the use? I am not having that kind of money. Only a person who is having the power and capacity to make a claim is only legally valid to say such things or is correct to say. So what does it mean? What does the nemo that got non habit means? It means a person in capacity is only able to sell or a owner of good can only sell a property. A non-owner cannot make valid transfer of property in goods. That is a fundamental principle of sale. Whereas there are certain exemptions for this rule. That exemptions are detailed below here. This has been repeatedly asked in a question examination. One example is sale by mercantile agent. If a mercantile agent is authorized by the owner of the goods to sell on his behalf, then such sale shall be valid. In car showroom, there will be a salesman. The car does not belong to the salesman, but he acts on behalf of his owner. So there is a this is an exemption. So sale by mercantile agent, transfer of title by estoppel. What does it mean? This exemption is based on principle of personal estoppel. Sometimes the real owner may lead the buyer by virtue of his conduct or words or by act to believe the seller he is the owner of the goods and has the authority to sell them. In such case, he may not thereafter deny the seller authority to sell. What does it mean? Suppose I am standing near a car and it is a expensive like a Mercedes car, and I am acting as if this is my car. A buyer who is interested to buy came near me and I started to act as owner and made the other person believe based on my action that this is my car and entered into sale. Suppose after the sale is done and the buyer has some grievance. Later on, I cannot sell or tell. I cannot tell this is not my car. Based on my actions, I made the buyer believe I am the owner. So I cannot later on escape from the liability. So one shall be responsible to buyer if he or she made the buyer believe that the seller is owner of good. Next, sale by joint owner. As per section 28, if there are several joint owners of goods, one of them if has sole possession of the goods by permission of co-owners, then property in goods is transferred to any person who buys them from such joint owners. So there may be situation where a single good may be owned by joint owners or more than one owners. In such case, a single owner can act on behalf of other co-owners and that sale is deemed valid. So is a most repeatedly asked kind of concept. You can imagine an example or in examination, if any of these conditions may be given as in an example. You are required to identify that situation and give answer accordingly. One of the most important concept in Sale of Goods Act, doctrine of caveat emptor. Let the buyer be aware. This is fundamental principle of law. Anybody who purchase any good is requested to have a fair and good idea regarding this good. It is the responsibility on buyer to be aware of the good that he or she is purchasing. So the liability at last falls on the shoulders of buyer. The term caveat emptor is a Latin word which means let the buyer be aware. This principle states that it is for the buyer to satisfy himself that the goods which he is purchasing are of quality which he requires. If he buys goods for a particular purpose, he must satisfy himself that they are fit for the purpose. The doctrine of caveat emptor is embodied in Section 16 of the Act, which states that, subject to the provisions of the Act and of any other law for the time being in force, there is no implied warranty or condition as to quality or fitness for any particular purpose of goods supplied under a contract of sale. It is not the seller's duty to give the buyer the goods which are fit for suitable purpose of the buyer. If he makes a wrong selection, he cannot blame the seller if goods turn out to be defective or no do not purpose, but do not serve his purpose. This is a key principle of caveat emptor. If he makes a wrong selection, he cannot blame the seller if goods turn out to be defective or do not serve his purpose. So these are the important concepts in this chapter. Students can go through different kind of examples and expect a example be given and asked to identify the concept or give a legal opinion. Thank you for watching.